Hello, good morning, everyone. This is Nick Caracal. I will just give you a very quick update on USCIS response, especially in this time with the coronavirus pandemic. So, if you have questions, as usual, you can actually just write your questions on the comments section, and then I will try to go over them and respond to them during the Facebook Live. Pakiusap ko lang kung may mga tanong kayo na not necessarily related to the topic, if you could actually just spark those questions because I will just entertain those questions related to coronavirus and how it impacts existing applications. Hello, Sir Ricky. Hello, Ma'am May. Good morning. Ma'am Gigi. Okay, just to proceed, I would just like to have a reminder that again, this is for general information only. My responses to you does not qualify as a specific advice to you and does not create attorney-client relationship. Sino ba dapat ang manonood nito? Those people who have or non-immigrants who are currently in the US whose visa has expired or about to expire during this pandemic. Those who are waiting for their work permits, those who are receiving notices of action requiring a response, halimbawa may intent to deny kayo or RFE, those green card holders waiting for their citizenship interviews, and all those concerned citizens involving parents, relatives, friends who may know somebody whose visa has expired or about to expire or and they are still in the US. Please tell them to watch this video because this might help them maintaining status in the US. Okay, so I would just like to give you that, hey, the basis of our presentation today is coming from USCIS website that as of March 18, 2020, USCIS temporarily has suspended routine in-person functions. So meaning lahat yung mga nag-i-interview in person or those appearing for biometrics or fingerprinting has been canceled yung mga appointments nila. And USCIS is planning to reopen again on May 4, and that is assuming that the situation has already been improved. So let's still watch kung yung May 4 is mag-open na ba talaga sila o hindi. So field office appointments and rescheduling will continue to perform duties that do not involve contact with the public. So it means that we are still able to file applications. Your applications that do not require in-person decisions will still be decided upon. So example, if you file for an extension or if you file for a work permit, they are still going to decide on that within a specified time. I don't know if there are still people in the USCIS offices, but I would presume some of them are working from home and are able to make decisions on those type of applications. So tuloy-tuloy pa rin ang pagpa-file natin, and then tuloy-tuloy pa rin ang pagde-decide nila on applications that do not require in-person adjudication or decision-making process. So the USCIS offices are actually sending out notices na kung may mga schedule kayo for appointments, they has been automatically rescheduled or has been canceled. So just wait for your notices in the mail kung ano yung mga nangyayari sa applications nyo. So no need to be worried about, but there are applications where there are automatic responses. May mga applications din na you have to make an action or you have to call the USCIS or the contact number that I will be providing you in the screen in a few minutes. Okay. Those who have filed InfoPass. So I would just like to explain what InfoPass means. Ito yung mga applications na some offices, not all, because there are offices which are no longer accepting InfoPass. Ito yung pupunta ka sa office ng USCIS to have an in-person meeting with the officer. So they used to accommodate those for emergency reasons. But as of now, may mga offices nag-cancel na o hindi na nila in-accommodate yung InfoPass na yon. But some offices still do accept InfoPass. So kung mayroon kayong InfoPass schedule, you still have to call the USCIS call center. And I think you know what the number is. And if you don't, you can just visit uscis.gov to get that number. So yun yung directions nila sa ngayon. Biometrics or fingerprinting. Ito maraming mga naapektuhan because people who are applying for extensions or change of status are now required to appear for fingerprinting or biometrics as we call it. Lahat na nakaschedule are automatically canceled. Kung meron na kayong previous biometrics, you will also receive a notice from USCIS telling you that they were able to reuse your fingerprints. So no action is required from you. So that's actually a good news because that's hindi na kayo magwo-worry pupunta pa sa USCIS with a lot of people there. But again, there is no requirement for you to appear in person. So they will reuse your previously captured fingerprints. However, for those na first-time applicants, as soon as the pandemic is gone and the USCIS will resume operations and you do not receive your biometrics or fingerprinting appointments within 90 days, then you have to call this number, 800-375-5283, and demand an appointment letter so your applications will not be abandoned. Hello everyone, Angie, Ella, Fe, good. Ayo-ayo mo sa Davao. Marlon, I hope that our J1 teachers in US Virgin Islands will be able to watch this because this might affect a lot of your colleagues there. The good news is you have some remedies, no? So let's just watch in the next slides. So still, yung extensions of work permits or those who are applying for work permits, the good news is they will still be able to decide on your applications without you having to worry about appearing for your interview. So for those applying for extensions, they will reuse your previously submitted biometrics. And again, no need to appear for biometrics appointment. Naturalization oath ceremonies. So yung mga taong may schedule na dati for interview oath-taking ceremonies, those activities are also being canceled. However, you will receive a notice for rescheduling by mail. So no need to call USCIS. So you just wait for your rescheduled appointments by mail. However, if you do not receive a notice within 90 days, again, after, let's say, May 4, you have to call the USCIS contact center. So for our clients, we will take care of that on your behalf. But for those na hindi namin clients, you really have to call USCIS, else your applications will be considered abandoned. Those people who are receiving notices requiring response. So this includes requests for evidence, so RFE, notices of intent to deny, notices of intent to revoke, and notices of intent to terminate. Normally, you are given 30 days plus 3 days, depending on how you receive the notice to respond. However, because of the pandemic, pupunta na ako sa next slide. Because of the pandemic, they will be able to give you an automatic 60-day extension. So meaning instead of just counting 30 days plus 3 days, you are now given 60 calendar days after the response due date. So I will just emphasize this a little bit, no? So normally when you receive a notice requiring you to respond, merong date dun sa upper left hand ng notice nyo. However, let's say the date there was, say, April 1, but you receive it on April 8. You have to use April 1 as the date of reference instead of the date that you actually received the notice. That's how it works, right? And then you start counting the 60 days from that date. It doesn't matter when you actually receive the notice. What's important is the date printed on the notice that you have. These guidance are only applicable for notices received between March 1 and up to present. So, ibig sabihin, if you've received these notices before March 1, you are still required to submit a response within 30 or 33 days, depending on how you receive the notice. May tanong lang dito, sagutin lang natin. Genesis Acoil, how about po yung mga B2 visa na nag-apply for extension? Lampas na po kami sa I-94. Genesis, you don't have to worry about that for as long as your extension or your change of status has been filed on time. It doesn't matter kung lumagpas ka na dun sa I-94 mo. It will still be considered timely filed and you are not incurring unlawful presence. Hopefully, the USCIS will give a decision sooner. And even if you don't receive a decision, kung the time improves, meron kang sinulat doon kung until when yung extension mo, you have to leave the US before that time. So let's say you applied in January 1, and of course you are given 6 months to extend, so you should be staying here until June 30. If you receive a response before that, then good news for you. Then you have to leave before your authorized stay expires. But if you don't receive a response or a decision before June 30, you are still going to leave the United States before June 30. But as far as lumagpas ka na sa I-94 mo, that you don't have to worry about that. You are still in status. Michelle, how about yung ma-expire na yung visa this April? May extension ba yung visa? Yeah, so I will go over yung mga visa expiration in my last few slides, but we will go over that. But those will be the big conversations natin for this presentation, okay? Babalikan kita doon, Michelle. So again, those people who are receiving notices requiring them to respond, you are now given 60 days, 60 calendar days to respond to the notice from the date of the letter, not from the date of when you actually receive the notices. So ito yung sinasabi ko kanina, no? Na even yung notice of appeal or filing a motion, you are now given 60 calendar days from the decision date before it takes action. Because normally, when your application has been denied, no, and especially for those applying for extensions or change of status, once your application has been denied, you may be able to file motion to reconsider or motion to reopen, and you are only given 30 days or 33 days to be able to file a motion. But in this case, you are now given 60 calendar days to be able to argue with USCIS na either mali yung decision nila or mali yung interpretation nila sa law. Okay? At least that gives you a little bit hope. The problem is, kung hindi ka magpa-file ng motion on those extension or change of status applications, you will be receiving deportation or notice to appear. Ibig sabihin, you will be placed in deportation proceedings, and your whatever visa you will have, it will automatically be canceled or revoked. And that might have bad consequences in your future applications for U.S. immigration. So again, yung questions natin about visa extensions, expiration, I will go over that in the last few slides ng presentation ko. Leah Witchen, so then again, all types of biometrics or fingerprinting, whether it's for ROC or removal of condition or work permits, don't worry about that. USCIS will, kung meron ka ng previous fingerprints, they will be able to reuse that. But if this is your first time to apply, they will give you a new schedule in the mail. So again, don't worry about that. Okay, ito na yung pinag-uusapan natin, extension or change of status, right? So for those who are not familiar with immigration law, I will just cover a little bit some principles here. So generally, non-immigrants, and that includes any person who are not green card holders or not U.S. citizens in the U.S. are considered non-immigrants, right? So kasama na dito yung mga tourist visa holders or yung mga work visa holders natin. Normally, they are given a document that say you are only allowed to stay in a certain date. For tourist visa holders, they are generally given 6 months upon arrival in the United States to stay here legally. So, yun yung sinasabi natin kanina na I-94, right? So, pag lumagpas na yung I-94 date mo, you are already considered out of status. So, sa mga tourist visa holders natin, if you did not file on time yung extension nyo or change of status, you are already out of status the day after the I-94 expires. It will automatically cancel your visa. Even if your visa says your visa is still valid until 2022, it doesn't matter, right? So, ang importante pag dumating na kayo sa US is yung I-94 nyo. So, kung wala kayo nun, you would be able to retrieve that online. So, generally, you are given 6 months from arrival. So, but USCIS also recognizes that because of what's going on now, you may not be able to leave the United States on time, and there is a possibility that you will be extending in the United States beyond what your authorized stay as reflected in your I-94. So unfortunately for people na hindi na rin nakapag file on time, meron pa ring remedy, no? Because again, USCIS has recognized of what's going on now. There is also another good news. Before, pag nag-submit ka ng application, it has to be in the original signature. But ngayon, with what's going on, USCIS will be able to accept reproduce signatures, right? So even yung mga scanned copy signatures, they would be able to accept that now because of what's going on. Those people who are applying for extensions, we'll talk about the options later. So before I proceed with that, sagutin ko lang tong mga tanong dito. FK, good morning, attorney. My mom is due to leave the US back to the Philippines of May 19. Expires on June 6 yung I-94 niya. So then again, sir, I would recommend, and this is the slide that I am actually showing now, that your mom apply for extension before June 6, unless there is still a possibility for her to leave the United States before June 6. But to be on the safer side, I would recommend that you file the extension of her visa before June 6. So again, i-generalize ko na lang ha, those applications who are requiring fingerprinting, kung nag-fingerprinting ka na before, they will automatically reuse that. If this is your first time application, your appointment are automatically canceled, and they will send you an appointment again for your biometrics when the condition improves. Okay, so isulat nyo lang dun yung question nyo sa comment section and I will try to answer them. From Shay Lapus. Okay, so this is a very interesting question daw. So ano naman ang mangyayari ng mga green card holders who are already outside the United States before this thing happens? Concept. Green card holders are allowed to stay outside the US for less than a year because if they are out of the US for 1 year or more, their green card status automatically are canceled or nawawala na sila ng being immigrant doon. So in that case, the remedy is to file a returning resident based on uncontrollable circumstance, in this case, the pandemic. If you still have the ability to fly back to the US before July or before yung 1 year anniversary mo, do that kasi it is by operation of law that yung mga green card holders natin na nasa labas ng US, magsistay ng 1 year or more, automatically they will lose the green card status even if the green card is still valid. So what you can do, you have two options, right? So again, when everything is improving na, you have to fly back to the US before the 1 year anniversary of you leaving the United States. Or if the worst comes to worst scenario, you have the option of filing a returning resident. It is a winnable situation because again, this is a pandemic and this is outside the control of who the green card holder outside the US. So you still have a remedy there. Hi, Risty, how about yung mag-apply for travel document and mag-i-expire na po siya next month? So, again, travel documents. Okay, so I just want to understand what the question is. For those who are applying for travel documents, so maybe you're referring to the re-entry permit. For re-entry permit, the requirement of the law is you have to apply for re-entry and have the biometrics while you are still in the United States. So, dalawa ang situation ang tanong mo dito, Resi, no? Una, before you would be able to leave the United States, you have to have a biometrics, else your application will be abandoned. But I am also not so sure if you will be able to travel outside the US considering na may nangyayari ngayon. So, I would recommend that you would wait until the condition improves, still have to have the fingerprints done before you leave the United States. So, para sa mga taong hindi nakakaintindi, people who are applying for re-entry permits are actually green card holders and are actually planning to go outside the US and stay outside the US for at least 1 year or more. But again, the law requires for those applicants to have their fingerprinting done first before leaving the US, else the application will be abandoned. Okay, so I think I've done that. So again, so yung mga taong mag-i-expire na yung visa or nag-expired na yung visa, you still have remedy though. You still have hope. Number one, we are talking about options now. You have to file on a timely manner your change of status or extensions. Even those visa holders na may mga limit, we'll just talk about in general the J1 visa holders na mga subject to the 212E. Ito yung mga people required to go home to the outside the United to their home country and comply with the 2-year requirement. The general rule is that they are given automatic 30 days extension after their visa expires to lawfully stay in the United States. And under normal conditions, they cannot apply for extension or they cannot change status because of the waiver requirement. However, USCIS is actually giving them remedy. You would be able to file for extension or a change of status. As noted, filing an application, a change of status or extension on time, while waiting for the decision of USCIS, you are not incurring unlawful presence. So, but however, while your application is pending and the condition has improved and you have not received a decision approving your extensions yet or change of status, I would recommend that you plan for departure outside the United States. However, as of this time, since hindi natin alam kung kailan maaayos yung condition na to, I would recommend that you file on time your change of status or your extension of stay. So that you will be able to maintain lawful status in the United States. Okay? So kung may tanong pa kayo regarding that, especially for the J1 teachers, you can write them here so we can discuss in more detailed specific scenarios. Okay? Yung mga non-immigrants who are working in the United States by virtue of your work permits on the employment side, if your work permits is about to expire, or has expired, your work permits has automatically been extended for 240 days. Some employers do not, hindi nila alam yon. So what I would recommend is you go to uscis.gov, search for the guidelines, and you can print them out and show it to your employer. But because of what's going on, your work permits on the employment side has been extended for 240 days. Sa mga work permits naman on the family base, so example, you've been married to a US citizen, you have applied for a green card, but your green card has not been scheduled for interview yet, but you've received your work permit and it's about to expire, it's automatically been extended for 180 days. It's about 6 months, right? So don't worry about that. You are still allowed to stay, you are still allowed to work legally in the United States. For people who are applying for extensions or change of status, it still does not exempt you from complying with the public charge requirement. So, ibig sabihin, if you are still in the United States and you're holding a non-immigrant visa, meaning you are not a green card holder, you are not a US citizen, and you are going to apply for extension or a change of status, hindi pa rin kayo allowed to receive public benefits. Okay? So, you have co-sponsors, you have employers, or you have your primary sponsor, they are still primarily responsible for you to support your financial needs or your living expenses in the United States. Because if hindi, then you will still be answerable for public charge challenges. Okay? Balikan ko lang yung isang slide just to go over in more detail extensions or change of status. So, we'll just see kung may mga tanong dito. Okay, so for Shay Lapus, ma'am, Shay, dalawa yung options mo dito. If you'll still be able to fly back to the United States before your 1 year anniversary, do that. There's no action required from you. You still have the green card status because your green card will be considered as your travel document. However, worst comes to worst, you are still outside the United States, nagwa 1 year ka na, then automatically by operation of law, your green card status has been canceled or revoked. The only remedy for you is to file for the returning resident visa based on uncontrollable circumstance. You will have a 100% chance of being approved, but you just have to go through that process. We have question here from Genesis. Thank you. Last question po. If nag-file kami ng extension for B2 tapos ang nilagay ay until June 20 lang po, mahirap pa rin umuwi. Okay, so then again, as a green card holder, as a tourist visa holder, you are only allowed to apply for one extension. But I think on the spirit of the law, I think what USCIS is saying, they will apply applications on a case-to-case basis. By reason of uncontrollable circumstance, they may be able to reconsider. But if I were you, I would still recommend filing the second extension before June 20. However, when everything improves, I would recommend leaving the United States before receiving a decision from USCIS. Because again, the general rule, while you have filed a timely application and there is no denial on that application yet, you have not incurred unlawful presence, and you still maintain your tourist visa in this particular case. Michelle, April 14 po dapat alis namin papunta US, kaso nag-lockdown at ma-expire na yung visa ng asawa ko sa April. Ma'am, the embassy will reconsider extending your visa because of what's going on. You have to file a request to the embassy. You have to submit some supporting documentation. Even if the embassy is aware of the pandemic, it is still your responsibility to provide them with additional supporting documentation. U.S. Embassy in Manila, in particular, is asking us to submit copies of the executive order for the travel ban or the travel restrictions from or outside the Philippines to be able to request for a new visa stamp. But there is a remedy for that. Don't worry about that. Mahish, my wife is in J2 currently as my J1 dependent. She will be starting new healthcare provider job on J1. Okay, for the J1 visa holders being asked by the sponsors to leave the US, okay, let me just quickly understand the question. So my wife is on J2 currently as my J1. She will be starting a new healthcare provider job on J1. She should change her status from J2 to J1, but she was told to leave for J2 to J1 conversion. I don't want to do that. Okay, Mahish, if you have time, can you just contact us later? Your question requires a detailed conversation. I am aware that most of the J1 sponsors now are advising their trainees to go back to their home country for obvious reasons, right? It is the trainees are the responsibility, whatever happens to them in the United States. But I guess there is a remedy to your question. I would recommend that you send us a message so that we can have a more detailed conversation about your specific scenario. Okay, so you have a clarification. So no, changing from J1 to J2 does not require you to leave the United States. So you could actually change status from J1 to J2. However, you need to go back to the home country to be able to get the stamp because USCIS are not allowed to provide stamp. But you can change status. However, you have to get the stamp in your home country. But then again, if you still need a more detailed response to your question, please send us a message. Rolly, good morning, attorney. My J1 program will end in 2021. So, may time ka pa, boss. Can I file for a change of status? Na-extend na po ako for 2 years. So, boss, there is no need for you to apply for a change of status. Number one, you are still in status. Your visa will expire in 2021. So, there's no action required from you at this point. Joseph, hello Sir Joseph, kumusta kayo dyan sa New Mexico? Ingat kayo dyan. My work permit will expire on June 1. Will it mean it has already been extended for 240 days? Yeah, so employment work permits has already been automatically extended to 240 days. But what I would recommend you is still apply for extension so you will receive a new work permit. If your employer is looking for evidences of extension, you can just go to uscis.gov and print that mandate that your work permit has been extended to 240 days. Hello, boss. Theodore. What's the difference between staying outside the US within a year versus just staying less than 6 months for permanent residence? If mabuti ang hindi lagpas ng 6 months. Okay, so this is a very good question. This question is intended for green card holders outside the United States. So kasi may man nag-a-advise sa kanila, hey, don't stay outside the US for more than 6 months, or you can stay outside the US less than a year. The relevance of that question, boss, is only concerning about citizenship eligibility. So it means that if you are staying outside the United States for 6 months or more, then napuputol yung requirement mo ng continuous presence for citizenship. It means if you stayed outside the US for 6 months, pagbalik mo, start from square one ka ulit. So if instead of, kunwari, eligible ka na for citizenship because it's your 4 years and 9 months na being a green card holder, if you stayed outside the United States for 6 months, pagbalik mo, magka-count ka ulit from zero. And then you have to count another 4 years and 1 day to be able to be eligible for citizenship. So, yun lang yung relevance ng 6 months na yun. So, if you don't want your eligibility for citizenship to be affected, then you have to come back to the United States within 6 months, not 6 months or more. Else, maapektuhan yung citizenship mo. Okay? Yung relevance naman nung 1 year, kasi nga by operation of law, if you've been out of the United States as a green card holder for 1 year or more, then you automatically lose your status as a green card holder. So I hope I was able to answer that question. For J1 extensions who are already, okay, if you're talking about J1, Sir Marlon, if you're talking about a J1 extension, that's within the jurisdiction of your J1 sponsor. No? So sila lang ang pwede mag-extend. So I would recommend that if they have been given authority to extend your J1 visa still, that you have to communicate or coordinate with them. In the worst scenario that they will not allow you to extend further, what I would recommend is you apply for a change of status for you to be able to maintain your lawful status in the United States. Taurus, I think this is related to a J1 visa. Yung question mo, can our visa sponsors prohibit us from traveling to PH due to the pandemic? So again, if you are a J1 visa holder, your J1 visa sponsor has a lot of jurisdiction over your visa. What I would recommend is you would coordinate with them what's the best strategy for you. If your question is related to yung visa mo mag-expire and you would still want to stay in the United States because of the pandemic, then your option would be to change status. to be able to maintain lawful stay. Okay. Okay. Sai. Sorry if I mispronounce your name. If change of status from B2 to J1 research applied and you stay in the US but the change of status applicant denied by USCIS. Okay, so um, any application for change of status or extension of stay, while it was, if assuming it was timely filed, for as long as you do not receive a denial letter, you are still in status. The moment that you receive a notice of denial, then you are starting to incur unlawful presence the day after the decision date. So, kung ano yung, whatever the date is in your denial letter, the day after that, you already started to incur unlawful presence. At that point in time, your remedy is to file a motion to reconsider or a motion to reopen and argue your case depending on the grounds of the denial. So in that case, I would recommend that you consult a lawyer to be able to help you. But for purposes of the question, yes, the day after the denial notice, you will start becoming unlawfully present in the United States unless you file a motion to reconsider or to reopen. If the person has left the United States within 30 days without filing a motion, then that person has incurred unlawful presence for 30 days. Christopher, attorney, pag tourist visa papuntang US kasama asawa mo, tapos nag-adjust of status ka for EB2, yung misis mo pwedeng po ba siyang magstay kasama mo? Yeah, for EB2 boss, your wife should be part of that application as your dependent. Change of status, I don't think, Ma'am Radzi, that if H1B is an option for you. So if H1B is a different conversation because you still be required to file a waiver, I think what USCIS is thinking as far as allowing J1 visa holders to apply for a change of status is yung change of status from J1 to B2, at least to be able to maintain their status here while this pandemic is going on. I think for H1B, they will still require you for the waiver. Genesis, can I change the 5 trains submitted po instead of applying again for another? No. By procedure, each application for tourist visa extension is only up to 6 months. So in that case, you have to apply for another extension. So I guess I've already answered all the questions here. Then I will just proceed with my last 2 slides. So then again, ang karamihan sa mga nanonood ngayon are those non-immigrant visa holders who had host visa has expired or authorized stay has expired or about to expire during the pandemic. What I would recommend is you file an extension or you file a change of status on time, so you would be able to maintain your status in the US. Family-based employment, as discussed with you, it's automatically been extended to 6 months and you still have to observe public charge requirements. So ito yung sinabi natin kanina, flexibility of late application. So if you have, na-realize mo lang ngayon, nag-expire na yung visa mo, you are still allowed to apply even if your visa has expired, arguing that the reason why you were na-delay ka sa pag-apply mo is because of the pandemic, that you have difficulty gathering your documents or your application because walang available or nag-lockdown kayo or walang available na courier service sa area nyo or you have difficulty gathering supporting documents. So try to argue that. However, the length of delay must be commensurate with the circumstance. So ibig sabihin, in your area, kung tinanggal na yung lockdown, then it's not an excuse for you anymore to file a delayed application. And again, it is your responsibility to submit supporting documents for late applications. Flexibility for waiver immigrants. So ito yung mga last slide ko na to. This pertains to Filipinos who already have become citizens of other countries. So halimbawa, they now become Australian citizens or citizens of Denmark. and then they come to the United States using the VWP program. So this is the visa waiver programs where Australian citizens or citizens of Denmark are able to come to the United States without the need of a visa. They are only required to file ESTA, the travel permit, and then they are only allowed to stay here for 90 days. Generally, they are not allowed to extend or they are not allowed to change status. However, because of the pandemic, they may be given an additional 30 days to stay in the United States, hoping that the situation will improve. For those who have already been granted 30 days and they are still in the United States, they have to call the USCIS contact center for another 30-day grant of satisfactory departure. If you don't do that, then you will start incurring unlawful presence. But then again, so may 30 days ka na allowed, then additional 30 days pang allowed if you are still not able to leave the United States. Okay, and again, thank you very much everyone for joining in. If you have questions, please write them down in the comment section. I will try to answer them even after the Facebook Live if I have time. Salamat and ingat kayo.